Welcome to Point of Law. My name is Cecil St. Pierre. I'm your host of the show. The purpose of the show is to inform viewers like yourselves about certain areas of law that may affect your daily lives. I'm a practicing attorney now for over 25 years with offices in Mount Clemens and Rochester in the areas of probate law, personal injury, and criminal law, and some family law. Today we're going to talk about an area that unfortunately has affected a lot of people, and we have our special guest here, Michael Greiner. Welcome to the show, Michael.
Thank you. It's great to be here, Cecil.
And Mike, you're a part of the Financial Law Group?
Yes, I am.
Now, you have a little bit of history with the city of Warren as well, is that right?
Yeah, I was the deputy mayor for almost 10 years and had a great time working with the city, but it was time to move on. I wanted to do something different, and I've really enjoyed doing my practice for the past few years.
And I enjoyed working with you. We got to serve together for a while, so we both have a little history. Now, you wrote a book.
I did, yes.
And when was this published?
Just recently published a couple months ago. It's with Norlights Press. Basically what it was is I see that there are people who would come into the courts and try to do the bankruptcy process on their own. And it's really not something I typically would recommend. You do have a right, though, under the law to represent yourself in bankruptcy court. It's a difficult process and kind of a convoluted process. But at least for some of the people where maybe they have a little bit of a simpler case, and they really want to file on their own without an attorney, I wanted to create a handbook to kind of guide them through the process. And that's basically what I did here. Again, it's not necessarily something I suggest to most people, but there are some people who can do it on their own. And for people who want to do it that way, this book can help them through it.
One more plug. Where can they get the name of the book, and where can they get it?
The book is called Bankruptcy 101. It's published by Norlights Press, and I believe that you can get it on Amazon.com or Barnes & Noble. So.
Well, you know, when you went out to practice law and someone said you're going to be doing bankruptcy law, not myself, but some other people also said, wow, what a tough way to start, because bankruptcy was not happening when you started. Yeah. And all of a sudden, did you foresee this where nobody else did?
Well, I'll tell you, I certainly didn't foresee this, but I think that's a little bit of a misconception, because the truth is people get in trouble with debt even when times are good. And in fact, in a lot of ways, sometimes people have more problems with debt when times are good than when times are bad. Because when times are bad, the creditors just can't collect. There's nothing to get. Whereas when times are good, there might be wages that could be garnished or that type of thing, which make it more difficult. But the truth is, the reason I went into this practice area is I've always actually been interested in bankruptcy. People think I'm crazy about that. But, you know, it's a great opportunity to kind of work with people, help them through a difficult time. Unlike with divorce law, a lot of the time people actually appreciate what you've done after the case is over.
Happy, but that means it's fair. But it's,
it is. That's true. And I've always been interested in finances and business, and you know, you get to kind of reorganize businesses. We do a lot of business bankruptcy too, and that I find really interesting too.
Now, statistically, I've heard some alarming statistics, but is Michigan one of the top districts? The Eastern District of Michigan, or anywhere else in Michigan? There's Western District.
Yes. Yeah.
Are they high up statistically in the country?
Yeah, actually, Michigan, and this was, again, also true before the economy took a turn to the south. Michigan has typically had either the first or second busiest bankruptcy court. This is the Eastern District of Michigan, which includes the Warren area and Macomb County. It's typically had the first or second busiest bankruptcy court in the country. So even though we actually have fewer bankruptcy judges here than, say, in Chicago, frequently we've had more filings per year than Chicago does, and that's actually pretty common around here.
All right, we'll get into the jurisdiction, and this is federal law as opposed to state law.
That's correct.
And why don't you tell people where it's found in the U.S. Constitution?
It is found in the U.S. Constitution.
They were thinking about bankruptcy when they formed the Constitution.
They were. Well, you know, you have to remember too, a big part of when the U.S. Constitution was founded, it was written in a way to do things differently from how things were done in Britain. And one of the issues that they had in Britain was, how do you deal with people who owe debts? And of course, we've all read, you know, in high school, Dickens and debtor's prison and that type of thing. And it's kind of an untold story a little bit, but they wanted to do things a little bit differently here in the United States. They did feel one thing that was important was that there be a uniform law for it throughout the country, and that's why, again, it's in the Constitution.
And this federal law is equal to everybody in the country, correct?
It is. There are some changes by state, and sometimes bankruptcy gets kind of considered almost a procedural law, because the actual like property law, the way that you own your own property, the way that you have contracts with other parties, those relationships are still governed by state law, but then the bankruptcy law can kind of step on that and say, this is how we're going to adjudicate these issues if you don't have the money to pay your creditors.
Now, you also talked about the district court judges, and despite having the highest number of filings, we have the same in probably every jurisdiction. Also, there's the trustee in bankruptcy, which everybody should be afraid of because they have a lot of power.
They do.
And the judges want to make sure their orders get followed. Why don't you tell people how the trustee plays a role in the bankruptcy courts?
Well, the interesting thing when I meet with a lot of clients is that they expect that they're going to go to a hearing and get to see a judge, because that's what you see on TV or what you're used to hearing about. Most people, though, who go through this process actually never see a judge. A lot of what the judge does is handled administratively, but they actually do have to go to a hearing. Typically, they'll have their bankruptcy attorney like me with them. But the person who will be doing the questioning is actually the trustee. And the trustee is essentially an attorney. It doesn't have to be an attorney, but usually it is, appointed by the court to represent the creditors. And the goal of the trustee is to try to get some kind of recovery from you, the debtor, to pay back your creditors. So even though, I always tell my clients, even though this trustee may be very nice and get along with you and seem like a great person to talk to, you have to remember that is the person on the other side.
You know, in October 2005, I remember during the Bush years, they made some sweeping changes to the bankruptcy law. I guess the vision was to have Chapter 13 as more for people pay off some of the debt, and supposedly you wouldn't be able to get rid of credit card debt. What effect did this economy have on that vision by Bush and Congress?
Well, it's certainly, the change in the economy has certainly made it more difficult for people to file Chapter 13. Part of what Chapter 13 requires is that you make a payment going forward over 3 to 5 years. And the goal, you're absolutely right about that, Cecil, was to try to push more people into Chapter 13 for longer periods of time rather than just 3 years, more like 5 years, and to pay at least some percentage of your debts back. But with so many people being out of work and so many people really having lower sources of income, unemployment periods, that type of thing, it's made it harder for people to make these payments in Chapter 13 going forward. And one of the requirements in Chapter 13 is that you have to have a regular source of income. So if people are in and out of work, then they're not in a position to make these payments. It's been a mixed bag, quite frankly, because on the one hand, Chapter 13 has always been a good tool to help people keep their homes, for example, when they're facing foreclosure. And now, I'll tell you, I think that this is really one of the best ways for people to get a mortgage modification in some respects, because a lot of people out there are sitting out there with first and second mortgages. And the second mortgage is wholly unsecured. You know, there's no equity in the house to support that second mortgage. So what a lot of people are able to do through Chapter 13 is actually just get caught up on the first mortgage and then wipe out the second mortgage through this process. And that can be really useful.
Now, rumor has it they're doing deals on the second mortgage. Even if you just threaten bankruptcy, you can get rid of it so many cents on the dollar.
Absolutely, absolutely, because they know that they're really out there. I mean, at this point, a second mortgage is no better than a credit card as far as the creditor is concerned. Because if they try to foreclose, exactly, it has no value.
Something that people don't realize, there's voluntary and involuntary bankruptcies. Do you see very many involuntary where someone takes someone and tries to bankrupt them?
No, that's pretty unusual, actually. And usually it would be something that would involve a business. And the creditors could essentially say, look, we want to take this company bankrupt because we believe that there are assets there that can be liquidated, that we can get something back, more at least than we're getting back outside of bankruptcy court. The standard, though, is high. There have to be a certain percentage of creditors who request it. There has to be a certain percentage of the total debts that's requesting it, and they have to be distributed among the different kinds of debt. There are different kinds of debt that people have, and businesses for that matter. For example,
I tried to do it on behalf of a business, and
okay.
it was tough to pull off.
It's very difficult to pull off.
All right, in regards to filing for bankruptcy, it's much like filing a tax return in the sense that you file a form, a petition.
Correct.
And I'm sure it's in your book,
yes.
But maybe you can tell people a little bit, a petition or schedules, just like a tax return, very similar.
Yeah, it is similar. Lot of documentation required in terms of listing all the assets that you own, all the debts that you've got, describing your sources of income, describing your expenses on a monthly basis. The courts do put out specific schedules that they want you to fill out in a specific way so that we can kind of compare apples to apples and oranges to oranges when we're trying to figure out how a case should proceed. But it is a challenge filling them out if you don't have a background in the field, and that's, again, one of the things that I wrote about in the book, and I do actually have a sample petition in the book to kind of let people follow along a little bit. But you're right, that is the start of the process. It's like filing a tax return in some ways, a very complicated tax return, but a tax return nevertheless. And then there is a court hearing set up, again, where they would typically meet with the trustee.
What is the requirement and I know it has to be shown in the petition, what's the requirement? You can't pay your bills? Your income?
That's essentially what it is. That basically, after you've paid your bills, that you have less than $100 left per month to pay toward your creditors. And that's one of the tests, but that's pretty much the primary test at this point. They did, back in 2005, you were talking about the change in the law, and what really they used to try to push people into Chapter 13 is something called the means test, where the means test kind of formalizes that test, kind of looks at, this is your specific income that we're looking at, these are the specific kinds of expenses that you can apply against that income, and at the end of the day, do you have less than $100 left to pay your creditors? And if that's the case, then you're eligible for Chapter 7 bankruptcy.
In regards to dischargeable versus non-dischargeable debts, let's touch on that before we go to break here.
Okay, absolutely. Well, the most debts are dischargeable, and in fact, a lot of people think of certain debts as non-dischargeable. For example, your mortgage or your car loan. They actually are dischargeable. It's just that frequently people will continue paying on those debts, do what's called a reaffirmation agreement, so that they can keep their home or keep their vehicle, or sometimes even boats. I've seen people keep through this process. Because
everybody that signs a mortgage note, just like any other promissory note, and it's a debt.
You got it, exactly right. In fact, well put. The credit cards are all dischargeable. I'm frequently asked about medical bills. They are dischargeable. Really, the major categories of non-dischargeable debt would be debts that are created through a divorce decree, for example. Alimony, child support, that type of thing are non-dischargeable. Recent taxes that were incurred within the last 3 years are typically non-dischargeable. And then student loans, which something I'm opposed to, but unfortunately I didn't get to write the law, and maybe someday one of us will get to have some impact on it. But unfortunately, right now, student loans are non-dischargeable, and that really is a big problem long-term, I think, for this country.
Intentional assaults also, assault and batteries?
That's true. There are a number of other listed things. For example, if you are trying to defraud a party, that would be non-dischargeable through this process. Another example would be, for example, if you were involved in a drunk driving accident and there was some requirement that you do repayments based upon that accident, that would actually be non-dischargeable through this process.
How about I do too much criminal law.
Sure.
Restitution.
Restitution sometimes is dischargeable, sometimes is not. That would be one of those tricky areas in the criminal aspect, absolutely.
All right, we're going to come back here after break, and we're going to talk about secured versus unsecured claims and the difference between Chapter 7 and 13. We're here with Michael Greiner from the Financial Law Group, who wrote Bankruptcy 101, an insider guide to filing bankruptcy by yourself without an attorney. I don't know if attorneys like that, but we'll be right back right after these messages. Thank you.
It's easy to tell if you've had way too many. But what if you've had just one too many? Buzz driving is drunk driving.
Welcome back to Point of Law. We're here with our special guest, Michael Greiner from the Financial Law Group, who has an office on Hoover just north of 12 Mile Road.
That's correct.
And has wrote the book Bankruptcy 101, and we're talking about bankruptcy law. We're seeing more and more of it these days, and I don't know if it's going to get worse before it gets better. But if there's anything to know about bankruptcy, this is the man to talk to. In regards to, we said we'd come back and talk about secured versus unsecured claim and maybe priorities. Does the bankruptcy courts look at that, and maybe you can explain to us?
Oh, absolutely. Well, secured debts, as you say, I mean, they would be things like your mortgage or your car loan or even a boat loan, things where basically the creditor has an interest in your property.
That's their collateral.
Exactly. They have collateral. And what they can do is if you don't pay your loan, they can take back that collateral to at least get some kind of recovery on the debt that you owe. Unsecured debts would more be like